Hey there, future legal eagles. Welcome to your complete guide to the Indian Evidence Act of 1872. This act is the backbone of the Indian judicial system, and knowing it inside out is crucial for any law student. First up, let's talk about the basics. The Indian Evidence Act was enacted on the 15th of March, 1872, and came into force on the 1st of September, 1872. It was crafted to consolidate, define, and amend the law of evidence. The Act is divided into three parts: relevancy of facts, proof, and production and effect of evidence. Part 1, relevancy of facts, covers sections 1 to 55. This part deals with what kinds of facts can be considered by the court. Think of it as the filter that determines what's important and what's not. For example, facts that are in issue and relevant facts are admissible. But what does that mean? A fact in issue is something that needs to be proved or disproved to resolve a case. Relevant facts are those that have a logical connection with the fact in issue. For instance, if the fact in issue is whether person A committed theft, evidence showing person A was at the crime scene would be a relevant fact. Moving on to Part 2, proof, which spans sections 56 to 100. This part addresses how to prove those relevant facts. Key concepts here include oral evidence, documentary evidence, and presumptions. Oral evidence needs to be direct, that is, first-hand accounts. Documentary evidence involves any documents presented in court. Presumptions are assumptions the court can make unless proven otherwise. Finally, Part 3, production and effect of evidence, sections 101 to 167. This part dives into who has the burden of proof, how evidence should be produced, and the effect of various types of evidence. The burden of proof generally lies on the person who asserts the fact. So, if you claim someone owes you money, you have to prove it. And that's a whirlwind tour of the Indian Evidence Act 1872. Each section is a building block to understanding how the law views evidence. Dive deeper into each part, and you'll start seeing how it all fits together in real-world cases. Until next time, keep studying and stay curious. Hello again, legal enthusiasts. Now that we've covered the basics of the Indian Evidence Act 1872, it's time for a deep dive into its sections, from Section 1 to Section 167. This journey will be filled with detailed explanations and real-world examples to help you grasp the significance and application of each section. Let's start with Section 1. This section lays the foundation by defining the scope and applicability of the Act. It states that the Evidence Act applies to all judicial proceedings in or before any court, but not to affidavits presented to any court or officer, nor to proceedings before an arbitrator. Moving on to Section 2, which provides definitions of key terms used throughout the Act. For instance, it defines court as including all judges and magistrates, and all persons, except arbitrators, legally authorized to take evidence. Section 3 introduces us to the concept of evidence itself, defining it as all the means by which any alleged matter of fact, the truth of which is submitted to investigation, is established or disproved. It includes both oral and documentary evidence. Next, Section 4 deals with presumptions and their classifications. It explains the difference between may presume, shall presume, and conclusive proof. For example, if a document is produced by a public officer in the discharge of his official duty, the court shall presume its genuineness unless disproved. As we delve into sections 5 to 55, we explore the relevancy of facts. For example, Section 6 introduces the concept of the res gestae, meaning facts which form part of the same transaction. A classic example is the spontaneous statements made by a victim immediately after an incident, which can be highly relevant in court. Section 8 discusses the motive, preparation, and previous or subsequent conduct. This section is crucial as it helps establish the intent behind an action. For instance, if a person buys poison the day before a suspected poisoning, this act can be considered under this section. Section 24 to 30 cover confessions. Section 24 states that a confession made by an accused is irrelevant in a criminal proceeding if it appears to the court to have been caused by inducement, threat, or promise. This ensures that confessions are made voluntarily and not under duress. Sections 56 to 100 dive into the proof of facts. For instance, Section 60 mandates that oral evidence must be direct. This means if a witness is testifying about something they saw, they must have seen it themselves. Section 65B is particularly noteworthy in today's digital age. It deals with the admissibility of electronic records, stating that any information contained in an electronic record is deemed to be a document and is admissible as evidence. Finally, Sections 101 to 167 cover the production and effect of evidence. Section 101 states that whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts, which he asserts must prove that those facts exist. This essentially places the burden of proof on the person making the claim. Section 114 provides the court with the power to presume the existence of certain facts. For example, if a person is found in possession of stolen goods soon after the theft, the court may presume that they are either the thief or have received the goods knowing them to be stolen. And there you have it, a comprehensive walkthrough of the Indian Evidence Act 1872, from Section 1 to Section 167. Each section plays a vital role in shaping the judicial process, ensuring that justice is served based on solid evidence. Stay tuned for more in-depth discussions on each section in our upcoming videos. Keep learning, stay curious, and see you next time.